All right. Welcome, everyone. Thank you for joining us. I'm Amanda Singer with West Coast Family Mediation Center. I am a family mediator, licensed attorney, and a certified divorce financial analyst. And today I have Nicole Boros with me. And Nicole and I are going to be talking about premarital or prenuptial agreements. You'll hear us probably refer to them in many different ways, whether it's premarital agreement, prenuptial agreement, or even prenup. They're all the same thing, just kind of different terms for them. And Nicole and I are going to talk just about, what are some of the requirements in California, some of the things that her and I have both seen working with clients on these types of agreements, and things like that. So Nicole is a family law attorney. I'm going to let her tell you a little bit more about kinds of cases and clients that she works with, and then we'll dive into our conversation today. Hi, Nicole.
Hi. Well, thank you for having me, Amanda. I am a family law attorney. I'm certified as a specialist in the area by the state bar, and I've been practicing since 2008. And my practice focuses on divorce, child custody, and prenuptial agreements. And I've kind of broken my practice out into two areas. One being litigation. So those are cases where the parties have a contested issue that really can only be decided by the court. And then the other half is assisting individuals that are going through the mediation process, and I act as the consulting attorney. So they could be going through the divorce or child custody or even a prenuptial agreement, but I'll act as the consulting attorney while they work with the mediator to try to come to a resolution on those issues.
And that's where Nicole and I have worked together on various cases. I've also will refer her clients that are not appropriate for mediation, but where her and I have had the opportunity to work together are clients that are in mediation. And I think what's wonderful is that, Nicole, you're always able to provide them the advice and the information they need, while also just being so supportive of the mediation process. And as you said, that could be, for divorce clients, but also, as we're talking about today, for kind of premarital and prenuptial agreements. And so when we're talking about a premarital agreement, we are talking about an agreement that future spouses are negotiating and putting into place before they get married. There can also be postnuptial agreements, which we can certainly, maybe talk about a little later as well. But when we're talking about that, we're talking about it pre-marriage and putting together some sort of contract agreement that the future spouses want in place. And so something Nicole and I were talking about a little bit before we started is that, myself as a mediator, I do, and we do a lot of premarital mediation. So being able to sit down with both of the couples and, both of the future spouses and talk through the issues and everything that they want to go into their premarital agreement. However, with that, there's requirements for a valid prenup in California, no matter how you do it, whether it was mediation or whether each party just had their own attorneys. So Nicole, I was wondering if you could explain just a little bit about what some of those requirements are so people understand if they're going to enter into a hopefully valid prenup, what does that need to look like?
Yeah, so first and foremost, it has to be in writing and signed by both parties. So, an oral agreement between the two of you is not going to stand up, but you need to make sure that it's in writing, and there's certain requirements that follow for a contract for it to be valid. So those are, issues that are concepts that most parties are not aware of. So it's really important to make sure that you have someone that ensures that those are included so that you write out your agreement, but that it also has those terms that ensure that it's valid and enforceable later on. It also cannot promote divorce. So it can't have any provision in there that's going to really give either party an incentive to become divorced. It also must be executed voluntarily. So, neither person can be under undue influence or fraudulently induced to enter into the agreement. So there can't be promises that are made by one party that aren't going to be fulfilled and are only being told so that the other person signs the agreement. And both parties have to really understand what they are entering into. And that comes into play if there's any type of language issues. So we want to make sure that the agreement is in a format that each party can understand and read in their native language. And then also if there's any type of spousal support waiver, which I'm sure we'll get into a little bit later, but there's certain requirements that have to be included if there's a waiver on top of the requirements just for the actual prenuptial agreement.
Yeah, Yeah, Bill, thank you for sharing all of those. And I think that, one of the parts that I know is always important to talk about with clients is you talked about, making sure they enter into it voluntarily and no, nothing was fraudulent, is making sure that they've done full financial disclosure before they're entering into it. And I think that, when we're talking about a premarital agreement, that actually can be a really just important piece for, whether you end up with an actual agreement that you enter into or not. The fact that you're disclosing all of your full financial picture to your future spouse is really important. And I think that I've certainly seen where they may not have realized that that their future spouse had certain assets or debts, and so making sure that they have that full picture and information is really important. And I'm sure you've seen that as well.
Yeah, absolutely. And then there's also along those same lines with the undue influence, there's the 7-day requirements. That's actually the date upon which the party is presented with the final agreement. There must be 7 days between that date and the date that they sign. And you and I see that a lot where people are coming up on the wedding date. The wedding date is in 2 weeks and they're rushed to sign. Those are where we see some of the issues come up with, okay, is this person really in a position to enter into an agreement, to have the time to, review everything that's being presented to them? So we want to make sure that they start the premarital agreement process well in advance of the actual wedding, so that there aren't really any ways that either party can claim that they were under undue influence because they were rushed.
Yeah, that's a really good point. And I don't know about you, but I can't tell you how often people come and, like you're saying, I mean, they are starting it a month before the wedding. And it's not to say you can't, absolutely, but it is certainly A, more difficult to get everything done. And B, you run into these issues of making sure that you have enough time. What would you say is kind of like an ideal, like how much time, if somebody had all the time in the world and you said, okay, I want you to start your agreement at least, what would you kind of look at that as?
I would say maybe 6 months before. I think that's a good time frame, because at that point, you're committed to moving forward. Sometimes if you go too early in advance, people, they're not really, sure yet if the wedding's actually going to go forward on that specific date. So they're not as committed to the process. But I think 6 months, they can really start to focus on the agreement. Then they're done with enough time to deal with, all the other issues they have to deal with regarding the wedding as it gets closer.
Yeah, I think that's a very good point. And I will say, I don't know about you, but I think a small fraction of my clients actually come with 6 months. It's more, I mean, I think that I would say more common kind of 3 to 4 months when when it's longer. But I get those calls that are a month or two before the wedding. And it's the last thing that people usually want to be dealing with right before the wedding,
Right.
first off. And second off, I think there is just those concerns of making sure that there's enough time and everything. And the one thing I will say too, I've talked about this, I think, on prior videos before, but my husband and I, when we got married about a year and a half ago now, we entered into a premarital agreement. And I always said, like, okay, we're not going to be doing it last minute, right? We're going to have it done in advance. And still, I have to admit, we were signing it like 2 days before we got married. Now, granted, we had been talking about it for a long time and the terms had already been discussed, but it just kind of creeps up on you. So the sooner you can start it, kind of the better off you are overall.
It's so true. No one wants to go to the notary 2 days, before their wedding when they're dealing with their dress or invitations or seating charts. You want to deal with that well in advance. So as much
Yes,
time as
yes.
you can give yourself, the better.
Yeah, exactly. And we were eloping, so it was a little easier for us. But I can't imagine if you had family in town and you're dealing with all of those last minute things, it's not what you want to deal with at that point. So, well, let's talk a little bit about why, like in your opinion, why are prenups important? Why can they be important? I think that one thing I get sometimes is people saying, well, aren't they just for people who have a lot of money, right? Or for you've been married before. What to you are a few of the reasons why it's important?
Yeah, I think you can kind of look at it from two different ways. So first is when you are getting married, I don't think a lot of people really understand what happens to their property, their premarital property before they get married, after they get married. It's like they don't understand that they still have rights in their separate property, and whether those assets get commingled. So it's really, I think, starts the conversation between the parties of what's going to happen to what we have when we get married, just by law, without a prenuptial agreement, and how do we want to change that. So I think it just gets the conversation started as to what's going to happen for each of those parties. And then also, I think they're important at the time of divorce, unfortunately, if the marriage ends that way, because both parties kind of have an understanding of where they're going to start. They may already see in the prenuptial agreement that their spouse has certain separate property assets that they're going to be awarded. And so it's not such a shock, because if you've been married for 20 years, you may have forgotten that your spouse had $100,000, in an account that remains their separate property. And when you're looking at your property, you're thinking, oh, we're going to split everything. But if you have that prenup, you're kind of reminded, okay, I know that this goes to my spouse and the remainder is then going to be presumably split between the two of us. So I think it helps provide a better roadmap at the time of the divorce, and helps parties know a little bit more about what to expect.
Yeah, I think that that's both of those are great things to talk about. First off, like you said, when you're first getting married, I look at it as just the strong communication and a strong foundation, right? You're having those conversations. You're also doing it when you get along and you like each other and you're happy, which unfortunately you don't know if that's going to be the case at the point where you're getting divorced. Usually, that's one of those, at least one of those, is not going to be the same. And so
Right.
you're having these conversations when you want to support the other person and you want it to be an agreement that it works for both of you, but it's also just like I said before with the financial disclosure part, it's just about communicating that and having those conversations and going in with open eyes about what the situation looks like. And then, like you said, at divorce, if it comes to that point, you have that information. And I think that in addition to kind of the spouse, the spouse at that point knowing, okay, this is what might be separate property and what might be community, it's also a lot easier for them to know actually what that did look like at the point that they got married. Because I know we have both dealt many times with people who they say they came in with separate property, but it's so hard to figure out what that actually was. And at least with the premarital agreement, you have that information there, and then you may still need to go back and find statements, but it gives you a better starting point and something that you both agree on, as opposed to what can become a really big issue.
Yeah, absolutely. I think, just like I was saying, it's a roadmap that just provides the parties with some guidance. And that's not to say that the prenup can't be contested, which is a whole nother issue, but it
Yep.
at least provides the parties with, okay, here's a starting point. Here's what we know are going to be the issues. And I think hopefully it alleviates some of the conflict at the time of divorce.
Yeah, I think that's very true. And I think that one of the things you kind of brought this up before, but just the fact that I think that oftentimes people getting married don't understand what are the laws in California, right?
Right.
And because even I mean, I get people who come to me at divorce and are like, well, that account's in my name, that account's in his name. Like we always had separate accounts. And then I have to ask though, but did you have a prenuptial agreement? Did you have anything, saying that those accounts were separate? And inevitably, I'd say like 95% of the time, the answer is no. And so then we run into this. You have to explain to people what community property means and all of that, but you're explaining it at divorce when it doesn't change anything that they did during the marriage. Whereas if people are understanding this and getting that education when they're getting married, then they can make the educated decision. If they're going to keep separate accounts, well, do they want those to be actually separate property, or do they want them to be community? And there's just so much, I think, education that can go into it.
Yeah, I absolutely agree. You always hear, well, that wasn't our intention. At the time of the divorce, they say that. And unfortunately, there's really nothing we can do at that point if, it's just been money that they've acquired during the marriage and it's in an account in their name only. By law, it's not separate property, it's community property. So yeah, I think identifying what their intentions are at the start of the marriage and what they're going to do with those funds and those accounts is really important, and will help, like you're saying, them understand how it's going to be divided and dealt with at the time of divorce.
Yeah, certainly. And one of the analogies I like to use with clients, because I think, we're talking about premarital agreements, we're talking about people that are getting married and are happy at that time. And they don't want to think about divorce, right? They don't really want to think about what that's going to look like. And of course, nobody getting married plans on getting divorced, or why are they getting married? But I kind of like to refer to a prenuptial agreement as like insurance, right? Like, you don't buy insurance for your home because you plan on it burning down or having an earthquake or something. You buy that insurance because you hope it never happens. But if something does happen, you want to have a plan in place. You want to know what things are going to look like. And I think of a premarital agreement very similarly, in the idea that you're not planning, like you said, in California, it actually can't promote divorce, and you're not planning to get divorced. But if it happens, you have something that you fall back on and you have in place already.
Right. And I think that's such a good way to, if you're the party that wants the prenup, to explain it to the other party and just say, I'm not doing this to incentivize either of us to get divorced, but I'm doing it so that, yeah, it's providing us both assurances and really an understanding. And like you're saying, it's just like going out and getting a life insurance policy and providing the other parties to be the beneficiary. It's just providing that insurance and hopefully that peace of mind if something were to happen.
Yeah, certainly. So something you said, I think I'd love to hear a little bit more about. You talked about, like, if you're the one who wants the prenup, how do you kind of talk about that with your future spouse? Because that could be kind of a fraught conversation. Do you have any tips that you talk about with people? Like, if somebody comes to you for a prenup, and maybe they've mentioned it to their future spouse, but it hasn't been a big conversation. Do you have any kind of tips or things that you share with them?
Well, first, I asked them, what are their intentions with the prenup? Let's first identify what you want, because, there's nothing worse than going to your fiance and saying, I want a prenup, but you don't have any plan in place, right? You're just going to scare them. They're not going to know, what the prenup looks like. So I think having a plan for what your goals are really will help the other party feel a little bit better about what's being presented to them. And then I always tell people too, your fiance best. So you want to present it in a way that they're going to be open to that. So whether that means them speaking with their fiance directly about the issues, or I say, look, if you think that it will be better coming from a mediator, why don't you propose, the concept of a prenuptial agreement and going to talk to someone together so that you guys can both figure out, whether or not the prenup is beneficial for both of you. Because prenup should not be an adversarial process. And, I don't think the fiance should find out about the prenup from me saying, hi, I was retained by your fiance to do a prenup. So I think, it really depends on how their fiance is going to respond. But I think either going to them directly after consulting with an attorney and really finding out what they want, or, talking to a mediator so that the fiance really feels like, okay, we're in this together. And this isn't something that's just been planned behind my back. We're going to work on this agreement together, which I think is a really important aspect of the prenup.
Mhm. Yeah, I think that those are great things to think about, and I think that that's where I have found kind of the premarital mediation being so helpful. Is that, as an attorney, and I work in this capacity as well, but as an attorney for one person, you and I both know that we can only talk with and really advise, or we can definitely only advise, but we really can only talk with the client that we're representing. And that can be difficult when the fiance may not have an attorney yet, may not really understand what's going on. Whereas what I like when I work with those clients in mediation is I'm a mediator, I'm a neutral third party. And so it allows them both to sit down together, and then for them each to go back to their own attorneys, right? So your original client comes back to you and you make sure that it's what they had expressed to you in the first place. You make sure it's all written correctly and it's going to, protect them and they understand. And then that their fiance is now going to another attorney as well, but they've started from a place of working together, as opposed to you saying, the fiance finds out about it from, the attorney.
Yeah, absolutely. And a prenup doesn't have to be one-sided. There can be clauses in there that benefit both parties. And so I think the benefit of working with a mediator is making sure that each party's interests are included. And again, it just kind of decreases the animosity. And if one party is scared about the prenup, it reduces that and makes them feel more comfortable about the process.
Yeah, I think that that's a great thing that you said about that it doesn't have to be one-sided. I mean, honestly, it shouldn't be, right? And I think that if you can, that's I think sometimes one of some of my advice about how to present it to your fiance is it is about protecting both of you. And you may be at very different places financially. A lot of times people are, but how do we make it so that both of you feel comfortable coming into this marriage and knowing what that's going to look like? So I think that's very important. So I think that we're talking a little bit about kind of at the start of putting together a prenuptial agreement and maybe some issues that can come up there. But can you talk about what are some of the biggest issues that you see come up on prenups you've worked on?
Well, I was thinking about this in the context of there's the prenup and then there's the actual enforcement of the prenup. And so I think that it's important to work with someone who really understands how and if the prenup is going to be enforced, because you want to make sure that there's clauses in there that are really going to follow through with the intentions of the parties. And so the first would be relating to separate property. And I think that it's one thing to list out what your separate property is, but it's another to also kind of do that a little bit more in depth so that both parties understand how that separate property will be dealt with at the time of divorce. So for example, I had two of these recently, one where, a client came to me and expressed, well, the prenup says I have a separate property interest in all of these accounts. So I just get all this money off the bat. And the way that the prenup was written, it just said, yes, I have a separate property interest, but he still has to, show that money still exists and trace it. And it's a very complex process. Whereas I have another prenuptial agreement where it says, client has $150,000 interest in, X property, and the client gets that upon divorce. And so that one is very specific in that there's no tracing allowed. And so I think it's important to really, again, discuss what your true intentions are and make sure that you know what they are so that the drafting attorney can include those in the prenuptial agreement, because it's just going to alleviate some of the issues at the time of divorce. So, a lot of people think, I have a prenup, this is ironclad, nothing's going to happen to it. And I think it's understanding that there's ways to make it stronger. But you have to discuss what your intentions are and how you want it to play out. Other issues that I see come up with prenups relate to children. And I think that, most often when parties are getting married, they don't have any children together. And so they're drafting agreements that may make sense without having children, but once they have children, there's some provisions that they're really not going to make sense. They're not in the best interest of the child. So one, for example, is if a party has a separate property residence. Well, at the time of divorce, the other spouse has no interest. Well, if the family is living there with the kids, you want to make sure that there's some type of provision in there that protects the children and allows the children to stay there with the parents. And so again, it's without kind of going into a lot of details about it, it's just making sure that you're factoring in how does this agreement impact our children if and when they come into the picture, so that we're not just looking at our interests, but we're making sure that this makes sense when we have children at the time of divorce.
Yeah, I think that's a really good point and something that a lot of attorneys aren't always thinking about because they're thinking about what does the situation look like today, right?
Right.
And so if you have that where they're getting married and like you said, they either, don't have children, they may have children from a prior marriage or they don't have any children yet, and then what is that going to look like down the road? One of the things that I find comes up too when you talk about children is if you do have children from a prior marriage, so let's say this is a second marriage for one or both of the future spouses, well, that also can cause some issues or things to think about in planning, not only for divorce but also for death. And I always say to them, I'm not an estate planning attorney, so I'm going to refer you to somebody for that part after, but I want you to think about how does that play out with your new spouse, your children from a prior marriage, and coming up with agreements that your kids are going to know about too, right? So I think that thinking about children, either those that are not yet, don't exist yet, or also those that you may have from another relationship, are important parts of the premarital agreement planning.
Yeah. Another issue that I see come up a lot is the financial disclosures. No one wants to take the time to do that, whether it's in a prenup or a divorce. It's cumbersome. It's a lot of information. And just to kind of backtrack, when you and I are referring to that, we're talking about listing out every asset and debt that you have, and an approximate value for each of those assets and debts, so that it's listed in the actual agreement. And I think that sometimes people will kind of gloss over that, and they may forget about an account or some type of asset that may seem minor to them. And at the time of divorce, they'll say, oh, well, I had this asset and I just forgot about it in the prenup. Well, it becomes a little bit more difficult. So I think that putting in that time and effort with the disclosures and making sure that the valuations are as close as possible as you can, that really minimizes a lot of work that has to be done at the time of the divorce, because most often people don't have account statements and really can't get them if it's 10, 15 years ago. So if the disclosures are done right and people actually spend the time to provide that information to their attorney, I think it will help them in the long run. And it's also required, so it strengthens your agreement.
That's a very good point. Question for you with that: are you then required, like, do you ask your clients for a premarital agreement to provide you with statements like they might for divorce financial disclosures, or are you just saying making sure that you have the values as closely accurate in the agreement as you can?
I always give them the option and say, you can provide the other party with statements. I think that strengthens it. But at minimum, just providing more, accurate numbers. So if you have, 150,000 in an account, don't put 100 and then, try to get the extra 50,000 later. It's just taking that time to put the amount in there, or just, don't have a business and put unknown, put what the actual business is, what you think it might be. That's better than just putting 0, because then it shows you had a premarital asset and here's what the approximate value was and both parties agreed on it. So it just limits some of the conflict that may come up in the future.
Yeah, I think that's a very, very, very good point. And doing them accurately is going to save you that headache later, and show that you were thorough, right? And you disclosed everything, and you were honest too about what there was, and whether it was because you forgot or you don't know, right? The other person could try to say it as, well, they were trying to hide something. You just want everything to be clear, from that point, I think is really important.
Right.
So have you ever had issues with prenups where they haven't gotten married, or things like that the discussions have actually kind of broken that down?
Yeah, and it's always kind of unfortunate, but I think it also just opens up, like you were saying earlier, the lines of communication. And I think that it's something that should be discussed, and it is a complex issue. But yeah, I've had people who have said either we're not going to get married or we're going to hold off for a little bit, because we're realizing that these are issues that we need to discuss a little bit more in detail. And I'd rather them say that, say, we just need to discuss this, we need to figure it out, and before we enter into the marriage. Because as you were saying with postnuptial agreements, you can have an agreement after you get married, but there's a lot different considerations to factor in after the marriage and requirements. So it's not the same as a prenuptial agreement.
Yeah, so yeah, definitely. So I know we've talked about a lot of different things that are important, but if you had to kind of break out, what would you say as like top 3 things that are important for someone to think about if they're considering getting married and putting a prenup together? So then maybe they're not even sure yet, but kind of what are those things that you think are going to be the most important for them?
Yeah. So first is, what are you trying to protect? So that kind of goes back to first having an understanding of what your premarital assets look like if you get married without a prenup. And then what do you want to alter from that? So what is it specifically that you're trying to protect? People often say, I just want to keep everything separate. Well, does that mean, every expense, every all the income that comes in? So it's really narrowing down, what are you trying to protect? The second, I think, in that kind of flows from the first, but how are you going to handle joint expenses? So you can keep everything separate, but presumably you're going to live together. And even if it's a house that one party owns outright, there's still joint expenses like food and utilities and travel and things like that. So I think having an understanding of how you're going to deal with those, and more often than not, it's just a joint account and those funds, become community property. But I think outlining that and factoring that in it's practical because you're going to have these joint expenses. So you want to factor that into the agreement. And then the third would be just how the agreement impacts children. As I was saying before, you want to make sure that you're ensuring the provisions are protecting the children. And there's your assets and then there's your children. And so you want to make sure when you're dealing with the prenup, it's really only looking at your assets, but you have to look at it from the children perspective too, and how that's going to impact, what their rights are moving forward.
Yeah, I think those are three really important things, right? What are you trying to protect? How do you handle the joint expenses and how it impacts the children? And I think that some of those are things that people might not always think of as a traditional prenuptial agreement too. So I think that it is taking them to think about things that not all attorneys, I think, are kind of considering when they're putting together a prenuptial agreement, right? If you look at it as kind of the, like I said before, when people think of prenups just for somebody who has a lot of money, and they think of it just as, well, one person trying to protect everything they have. Well, it may not be that, right? It may be that there's certain things you want to protect and there's other things that you want to have joint, and having that conversation and making sure that it's discussed with with your fiance before you're getting married. All of those are really important.
Yeah, I think, and I find that you want to have a drafting attorney, and this is why I love referring parties to you that are working together, because you want a drafting attorney that understands what the agreement's going to look like at the time of divorce, because there's so many additional issues. And so I think that having both of that, those areas of expertise really strengthens your prenup, so that you don't have to come back and do a postnup or a subsequent agreement to add in additional issues.
Yeah, I think that's very important. And I think that it is, like you said, it's nice. I know that, if you're working with a client on a prenuptial agreement, you also do divorce work, right? And so you understand, how does this potentially play out later? And I think that that's, really important to know, because it's figuring out both what you want during the marriage, and if you did, right, in the unlikely or in the unfortunate event that you do end up getting divorced, well, then what does it look like then? And it's having them understand those different pieces. So, and I did want to, I know, and we're gonna wrap up in a little bit, but one thing we didn't really touch on was the idea of spousal support in a prenup. I would like to talk about that for just a few moments if we can, and I know that's a lot of information, so just to include a little bit. And I think that it's mainly comes up, I think, in the idea of like waiving, right? Like a spousal support waiver, and whether that's a full waiver, right? You could say that you and your fiance, or one of you, is going to fully waive spousal support in the future, or you could limit it. So maybe if you could touch on kind of some of those pieces. And I know that also then, of course, is more so tied to the future, maybe enforceability. But how does that kind of change some of the issues that come up in a prenup?
Yeah, so spousal support is kind of that additional issue that you have to look at beyond the property. And so, as you were saying, there's either a complete waiver, or there's some type of step-up plan relating to the length of the marriage and the amount or income fluctuation. So I think that's the first issue to realize, is that it doesn't have to be a complete waiver. You can do a lot of different creative solutions within the agreement that provides protection for both parties. The payor doesn't want to be paying a high amount, but the recipient wants to make sure that, if they're married for a long time, or if their income's at a certain level, that they're still entitled to support. But the most important thing is that if you are going to do a complete waiver, you have to be represented by counsel, and that's independent counsel. So that means, an attorney that person has found on their own, not someone that, was handpicked by their spouse and said, you must go to this attorney. That the other spouse can pay for the other attorney, but it has to be an independent attorney, not an attorney that the other party is using. And then the other issue is that the spousal support waiver cannot be unconscionable. So it kind of goes back to those cases where the parties had no money at the time that they got married, but at the time of the divorce, usually the husband, but it could be the wife, is making, a considerable amount of money, and the other spouse is making nothing, and all of a sudden they're walking away from a 20-year marriage with nothing. So the unconscionability aspect is one that there's really no concrete answer, and it provides the court with a lot of discretion. And that's why it is important to include as much information from the disclosures and ensure that the property division is fair, so that it's more likely that the spousal support waiver, if there is one, will be upheld at the time of divorce.
Yeah, it's very, very important. And I think one of the things that I find that I think is, I like talking about with clients, whether it's it's a little bit easier, of course, when they're mediating, but even if I'm representing one party, is if you're thinking about a waiver, why don't you think about maybe limitations as opposed to a complete waiver? Because you just never know what things are going to look like down the road, right? And you're talking about, like you were talking about, now child support's a whole different issue if you have children, so you're never waiving that. But that doesn't necessarily, if you're not working at all and you have children, child support isn't going to necessarily cover everything for your expenses. And so it's the idea that you don't know what things are going to look like down the road. And so putting in place limitations, I think, can make sense, right? So that the person who, is paying, either pay or has some idea that they're not going to be, paying forever, or pay, like there can be like things that are built in, but also you're doing it so that the payee has some protection, right? Knows that, I'm not just waiving it. I'm also not going to have to fight, there's some things that are already built into the agreement, because as I'm sure we both seen, spousal support is one of those issues in a divorce that is the most contested. And I think that's, I always say, because I don't care who you are, nobody wants to pay spousal support. And so if you can put some things in place in the prenup, and it's not a complete waiver too, right? You're less likely to have issues of unconscionability. And then you also just have some things in place already.
Right, too. And think about it, if there's a complete waiver of spousal support, the person who wants spousal support is probably more likely to say, well, hey, why don't I try to contest this? Because what do I have to lose? But if, there's what, like you're saying, if there are provisions in there that provide for spousal support after a certain amount of time or based on income, it also shows the court, if one party is trying to contest it, that the parties really gave these provisions some time. They put a lot of thought and energy into this. And so I think the court would be more likely to uphold an agreement like that, because they want to make sure that both parties' interests are being protected. And they want to kind of follow through on what the parties' intentions are. So I think you have a better shot at having the agreement upheld if there's not a complete waiver. Again, there's varying circumstances, but I think that's kind of a good option to consider when you're looking at the prenup.
Yeah, certainly. And I find too that if you are the one asking your fiance to waive spousal support, they're going to be more receptive to the idea of limitations too,
Right.
than they are going to be on an outright waiver. And so it makes that conversation one that, like you said, this is a prenup. It shouldn't be, acrimonious. It shouldn't be that. And so if you're doing it, because if you're thinking about it in a way that protects both parties, whereas a waiver doesn't really. And so this allows you to have that conversation in a way that is really thinking about both of your futures.
Right. Yeah, absolutely agree.
Well, wonderful. Well, thank you, Nicole. You've shared so much great information today, and we'll include your contact information in the notes as well. But what's the best way for people to find you if they, do have questions or interested in prenuptial agreements or other services you offer?
Yeah, they can go to my website, borosfamilylaw.com, or always just an email is a great way to connect as well. And then we can discuss, any issues. And I'm also happy to consult with individuals, because like we were talking about, it's important to just figure out what you want before moving forward. So happy to talk with people who just have questions and kind of guide them in the right direction. My email is nicole@borosfamilylaw.com.
Wonderful. Well, thank you, Nicole, so much. Thank you all for listening. If you have any questions, like I said, we'll post our contact information as well as ours. You can find us at westcoastfamilymediation.com. And thank you so much for joining.
Thank you, Amanda.